All right, we're continuing this chapter 3 previously from the live meeting to this slide. All right, so this slide goes with the issue, how it's looked at under civil law and how it's looked at under criminal law. You can pause here and look at this on your own. All right, so to be convicted of a crime, there's two elements that must exist. You have the criminal act, which is the actus reus, and the state of mind, which is the mens reus. The actus reus is the actual guilty act, and the mens reus is the wrongful act or the mental state. The corpus delicti, this is the actual starting point. So that's the body of the crime. So in a murder, that's the body. And in a bicycle theft, it would be the bicycle. Your actus reus is your guilty act. So the guilty act must be voluntary. So in a murder, the actus reus is the homicide. If a vehicle is stolen, the actus reus is the motor vehicle. The mens reus is the state of mind. So the person must intentionally, knowingly, and willingly commit the criminal act. So the reasonable man test is what it is. So your mens reus is your state of mind or intent. And this is a really great scale to look at, where on the left you have the lowest and on the right you have the highest, where the left being your general negligence, going from recklessness to general intent to specific malice to premeditation. Mens reus, or your state of mind. Insanity is where one lacks the capacity to appreciate the wrongfulness of the conduct. Under the influence of alcohol, the voluntariness is the key. Insanity. The definition of insanity, we have what's called the McNaughton Rule. In 1843, Daniel McNaughton was a deluded Scotsman, thought that the Prime Minister, Sir Robert Peel, was persecuting him. He tried to shoot him and instead killed his secretary. He was ruled insane and spent 20 years in a mental asylum until his death. The McNaughton Rule was to establish a defense on the grounds of insanity. It must be clearly proved that, at the time of committing the act, the party accused was laboring under such a defective reason from disease of the mind as not to know that the nature and quality of the act he was doing, or if he did know it, that he did not know that what he was doing was wrong. Here's a quick look at the different states and what rules on insanity they have, or if they don't have an insanity defense. You can pause here to look at it further. Here's also a look at justification and excuse defense and what it means to be under duress, to have a self-defense, necessity, or entrapment. There's also justification and excuse defense of age, insanity, intoxication, or mistake. You can pause here as well to read through further. Earlier, I brought up the reasonable man test. It means an individual is not liable in a criminal court for remote, unforeseeable, or indirect consequences which a reasonable person would not have foreseen as likely to have flowed from the act. There is a liability for the direct results of the act, but a diminished no criminal liability for remote, unforeseeable, or indirect consequences. Mal in se and mala prohibita. Mal in se is considered wrong even if there's not a law that prohibits it. It's inherently wrong. Natural and moral law. Example is murder. And mala prohibita, considered crime because it has been defined that way, put into statute or law. Varies from place to place, states, countries, localities. Examples: gambling. Criminal homicide is homicide that was neither justifiable nor excusable. So we have first-degree murder with premeditation, second-degree murder with malice, voluntary manslaughter with general intent, involuntary manslaughter, recklessness, statutory manslaughter with general negligence. We have the felony murder rule, which is any death which occurs during the commission of a felony can be considered murder. That's usually first-degree murder. And all participants in that felony or attempted felony can be charged as long as there is a causal connection between the felony and the killing. So, have you ever heard of somebody that drives the getaway car? So, 3 people drive to the convenience store, 2 people get out, go in, and steal all the money in the cash register and then shoot the clerk. And the person driving is charged with the murder as well. That's where you get the felony murder rule. Statute of Limitations. This means that just because we don't catch the person who murdered the convenience store clerk right away doesn't mean we can't charge them right away. It means that the length of time when we can charge them varies state to state depending on the type of crime. So the misdemeanors, let's say that somebody steals a bicycle. Well, yeah, the time varies for how long we can charge them. Usually for a misdemeanor, it's between 1 and 3 years. Murder, there's no statute of limitation. Other felonies, it's between 3, 5, and 7 years, and it depends on the crime. Sexual assault, a number of states are moving to remove the statute of limitations or significantly lengthen the time frame, especially for child sexual assault cases. Now let's look at what happens after a person or when a person is arrested and what happens after they're arrested. I'm also going to use the 3 C's of cops, courts, and corrections. So let's start looking at the first C of cops. So criminal procedures prior to prosecution. So we have somebody that's arrested, and when there's a detention, that's not considered an arrest. And in Oregon, when somebody is detained, an officer has a reasonable amount of time to detain them. So they can't detain them for like 3 hours. That's like not lawful. So if an officer has probable cause to think that somebody has committed a crime, that person can be searched and arrested. If somebody has a warrant, they have to have probable cause to believe that a crime was committed. If somebody wants to have a search warrant, they have to have probable cause. So this is where you have the cops. That's where we have the 3 C's. This is where our cops are in our 3 C's. Okay, we're still using our 3 C's. We're still in the cops. So now, after the arrest, we have our investigation. And generally that involves your detectives. They find and interview witnesses. They conduct searches. Witnesses may view suspects in a lineup. They may decide to change the offense. They may say, hey, we thought it was, second-degree murder, but it may be involuntary, manslaughter. We may release a suspect without a warning or referral to a social service agency. All right, now we're done with the cops in our 3 C's. Now we're on to the courts of the 3 C's. We're in prosecutorial discretion. They're looking at what the cops have done. The prosecutors have broad discretion. They decide whether or not to pursue a case, what charges to file. Their resources are limited. They allege as many offenses as possible. There's a greater likelihood of conviction because of that. The defendant may plead guilty to one in exchange for others being dropped. They formally charge persons before the court. We're still with the courts on that 3 C's now. Again, we've left the cops, it's with the courts. So when I was a cop, I didn't have any part of this. It's totally with the courts. The complaint is the statement of charges being brought. This is where the initial appearance is. This is where the defendant's taken before the judge or magistrate and told, hey, this is what you're being charged with. This is where the bail's done. We're still with the court. This is where the preliminary hearing's done. The judge determined whether evidence is sufficient to establish probable cause. This is where, hey, the prosecutor has read what the cops have done. They've decided, hey, we think that there's a case here. Everything's been done as it should. This is the first adversarial proceeding. Um, we're still with the courts. This is the grand jury. They're looking at the case. The prosecutors looked at the case again. The citizens said, hey, there's probable cause here. The indictment's been done. A true bill's been issued. We're still with the courts. There's been an arraignment. The defendant is informed of the charges. They must respond if they're guilty, not guilty, or nolo. There's plea bargaining that's done here. We're still with the courts. There's a pre-trial motion to suppress if there's evidence. We're still with the courts. This is where discovery's done. We're still with the courts. We're on to the trial. We're still with the courts. There's a presumption of innocence. We're still with the courts. We're on to sentencing. And we're still with the courts. We're on to diversion, and we're getting ready to go over the corrections, which we're going to do in another week. But this is going to end our chapter 3, and this is going to end our PowerPoint. We'll see you next time.